Hello friends, today we are going to discuss the title Qualified Immunity in Torts. Friends, we have understood from the previous lecture that some sort of immunity has been given to the sovereign when it comes to getting sued by individuals. So, immunity is granted to state as private individuals cannot sue it. The limits on such immunity in the backdrop of qualified immunity and judicial discourse will be discussed hereunder. The scheme of discussion is as follows. We'll start with the introduction, then the concept of sovereign immunity under Constitution of India, then the conceptual dimensions of qualified immunity, followed by exemplary legal precedents and conclusion. To start with the introduction, the main rule of tort law states that anyone who disobeys a mandate from the law has the right to sue the person responsible for the harm. The locus standi, which states that only those who have incurred a legal wrong are eligible to go to the judiciary for relief, is the foundation for this fundamental principle. This rule gave rise to the legal notion since it was based on the principle that the only person who can seek redress is one whose own rights are threatened. Only that person has legal redress when their personal or property rights are violated, and a person who suffers along with other members of the public administrative action cannot appeal the action in issue unless he can show some specific injury to himself that is above and beyond what other people have endured. Students, the court ignores a petition filed by a total stranger contesting an administrative action. Everyone has a legal right to sue and is susceptible to being sued according to the fundamental tenet of tort law. But at this point, this rule cannot be refuted. Due to particular infirmities, there are several exceptions to this general norm based on laws and situations. A tort claim cannot be made or received by some people. The notion of sovereign immunity is a principle that cannot be infringed, dishonored, or violated. Sovereign immunity is a legal principle that grants a sovereign state protection from being subject to lawsuits. Furthermore, it asserts that states are absolved of wrongdoing and are exempted from civil and criminal litigation and the obligation to compensate for damages. States frequently invoke the idea of sovereign immunity to protect themselves from the jurisdiction of foreign courts as a protective measure for the states in certain situations. States are likewise protected from being sued due to sovereign immunity. In the case of D. Haber versus the Queen of Portugal, 1851, states that no court can accept an action against a foreign royal for anything he did or failed to do while acting in his official capacity as the head of the nation he represents. It does not constitute a renunciation of immunity or consent to be subjected to local jurisdiction to reside in a foreign country. Nevertheless, there exist circumstances in which sovereign immunity does not apply. Sovereign immunity also faces criticism. This is commonly referred to as the rationalization of unlawful actions carried out by a government. Now, let's discuss the concept of sovereign immunity under the Constitution of India. Following India's independence, the courts in the country have consistently restricted the extent of sovereign immunity. This allows citizens who have been wronged to take legal action against the state and maybe get appropriate compensation if they are eligible for it. The Constitution of India does not explicitly provide for sovereign immunity, but rather it is inferred. Article 294 and 300 of the Constitution of India pertain to the sovereign immunity of India in the matters related to property, contracts, rights, liabilities, obligations, and suits. Both articles contain clear and tactic clauses about sovereign immunity. Students, Article 294 discusses the entitlements, responsibilities, and duties of both the national and state governments. According to Article 294b of the central and the state governments have the rights, responsibilities, and obligations that come from contracts or other sources. Students, the term otherwise encompasses any additional duties, including those arising from tort. Article 300 is a crucial clause pertaining to the concept of sovereign immunity. This pertains to the legal responsibility of the government and originates from Section 176 of the Government of India Act of 1935. Students, this provision explicitly states that the Union of India has a legal right to initiate or defend a lawsuit using its official name. Similarly, a state government also possesses the authority to file a lawsuit or be subject to legal action using the name of respective province. Now, let's discuss the conceptual dimensions of qualified immunity. Qualified immunity is a legal principle established by the courts. It protects government officials from being held accountable for wrongdoing even if they violate law. The US Federal Civil Rights Act, known as Section 1983 and found in 42 United States Code, states that if a state actor breaches someone's federally protected rights, they will be held legally responsible for the harm caused to the affected individual. However, according to the doctrine of qualified immunity, the court has determined that these defendants cannot be legally sued unless they have broken a law that is already well established. Although this criteria is flexible, it typically demands civil rights plaintiffs demonstrate a distinct legal principle and a previous case with practically comparable circumstances. Qualified immunity has unequivocally proven to be a complete failure in terms of its legal, doctrinal, and public policy implications. Legally speaking, it lacks any foundation in either the wording of Section 1983 or common law principles on which the Act was based. The contemporary theory, particularly the clearly established law threshold, cannot be consistently and predictably applied. As a result, it continues to create confusion and disagreement among the lower courts responsible for its application. Moreover, the concept consistently allows flagrant violation of the Constitution to remain unattended, intensifying a persistent problem of responsibility in law enforcement as a whole. Not only does police misconduct harm the victims, but it also negatively impacts the law enforcement community. When the judiciary consistently allows police officers to escape punishment for severe violations of constitutional rights, it significantly undermines public trust and respect for officers in the community. The erosion of trust and respect significantly complicates and increases the risks associated with the police task, even for those officers who try to behave legally and professionally. Students, when assessing whether a right was clearly established, courts evaluate whether a hypothetical reasonable authority would have been aware that the defendant's action infringed the plaintiff's rights. Courts undertaking this analysis adhere to the legal framework applicable at the time of alleged breach rather than the law currently in effect when the court evaluates the case. Typically, in qualified immunity circumstances, a plaintiff will initially file a lawsuit under the Civil Rights Act of 1871, Section 1983 against a public official. Subsequently, the public official will assert a qualified immunity defense which shields the official from legal repercussions save in cases of evident incompetence or deliberate breaches of the law, provided that the official's actions were reasonable albeit misguided. Students, qualified immunity does not protect individuals from financial liability but shields them from the expenses of a trial. Hence, it is imperative for courts to promptly address the qualified immunity matters, ideally before the commencement of the discovery process. To put it simply, it is feasible and frequently observed for courts to determine that government agents have infringed upon an individual's right. Yet, the victim cannot seek legal recourse solely because of this specific type of wrongdoing was not established in prior cases. The theory not only consistently denies justice to victims of severe injustice but also weakens ability to hold law enforcement accountable at a very fundamental level. Section 1983 was initially designed to serve as the primary method of holding governmental actors responsible for breaching constitutional rights. However, qualified immunity significantly undermines this legislation's deterrence and remedial impacts. The idea weakens the methods of upholding constitutional rights, undermining them universally. Students, qualified immunity is a legal concept that protects federally protected rights and can be effectively eliminated through the Supreme Court overturning previous rulings or Congress enacting legislation that define Section 1983. This would allow courts to determine if government agents have violated someone's rights, but without precedents, victims have no legal recourse. State actors will be held responsible for federally protected rights if they abuse someone's rights. However, alternate approaches exist to complete elimination. Revoke qualified immunity in most cases while retaining a modified form of defense in some justifiable situations. Qualified immunity serves as a legal shield against lawsuits seeking financial compensation for violations of federal constitutional rights and protects police personnel from legal liability in incidents involving excessive use of force. Consequently, removing qualified immunity would not immediately expose individual officials to financially devastating judgments. Instead, it would guarantee that victims of official misbehavior receive the appropriate compensation they are entitled to. Determining whether and how to compensate defendants is a complex policy issue. However, the initial action towards addressing this matter and promoting accountability in law enforcement is to reinstate the fundamental presumption that individuals whose rights are infringed upon will be granted a means of redress. Students, qualified immunity also shields government officials from being held financially responsible for infringing on constitutional rights. It does not limit injunctions, the exclusion of evidence, or the assertion of defensive rights in government enforcement processes. Furthermore, it does not encompass all instances of damage claims. Students, officers who carry out legislative, judicial, and specific prosecutorial duties are entirely protected from being ordered to pay money as compensation. On the other hand, municipal governments, which can only be legally held accountable for constitutional violations carried out as a part of an official policy or custom, do not have any protection against such abuses. However, executive officers, including law enforcement personnel, correctional officers, healthcare providers, welfare administrators, and government employers, typically have qualified immunity and are protected from being sued under certain circumstances. Qualified immunity is a legal principle that prevents awarding damages unless a defendant has violated constitutional rights that have already been established. Expressly, damages are prohibited if a rational officer may have concluded that their acts were legal based on well-established law. The campaign for police reform and racial justice has focused extensively on challenging the concept of qualified immunity following the murder of George Floyd. Indeed, and with good reason. Qualified immunity, a legal protection that exempts government officials from liability for constitutional crimes, should be eliminated from federal law. On May 25, 2020, George Floyd, an unarmed American African man, was mercilessly killed by a white police officer in Minneapolis. The New York Times released an editorial urging the Supreme Court to reconsider the concept of qualified immunity. Qualified immunity serves as a means to strike a balance between two crucial concerns: the necessity to hold public officials responsible for their irresponsible exercise of power and necessity to protect officials from harassment, distraction, and legal responsibility when they carry out their duties reasonably. In the case of Pearson versus Challen, this point was highlighted. Now, let us discuss exemplary legal precedents. In 1831, when East India Company was in power, the Supreme Court of Calcutta bravely refused to accept the company's request to be immune from legal action based on the claims of sovereignty. The Bank of Bengal initiated a lawsuit against the United Company in order to reclaim the outstanding interest on the promissory notes issued by the East India Company for the purpose of borrowing funds to finance the war. Sir Charles Grey and Justice Franks from the Supreme Court of Bengal definitively stated that East India Company lacked sovereign status, which meant it could be sued for the repayment of interest on 3 promissory notes. These notes were used by the company to borrow money for the purpose of effectively waging war to protect and expand the territories of the British Crown in India. Initially, the East India Company solely focused on commercial endeavors. However, over time, it obtained specific legislative and judicial authority through the involvement of different individuals. The sovereign immunity of the state was first discussed in the Peninsular and Oriental Steam Navigation Company versus Secretary of State of India, 1861. The plaintiff's horse was injured when an iron piece hit their carriage. The East India Company was held responsible for damages due to non-sovereign nature of the dockyard upkeep, and the government was held accountable for the negligence. In case of Saucier versus Cars, in 2001, the Supreme Court determined that a decision about a qualified immunity defense should be made at the beginning of the trial court proceedings. This is because qualified immunity serves as a defense against standing trial rather than solely a defense against liability. When a summary judgment move for qualified immunity is presented, the court must decide on the motion, regardless of whether there is still a significant factual dispute regarding the underlying claim. Students, in this case, the court further expounded upon a two-pronged examination to determine whether a government person is eligible for qualified immunity or not. Initially, a court must assess if the facts suggest a violation of constitutional right. Subsequently, the court must examine whether the right was unequivocally established throughout the time of the accused's behavior. Qualified immunity is applicable under the Saussure test unless the conduct of the official in question violates a specific right. In the case of Anderson versus Crichton, 1987, the Supreme Court ruled that if law enforcement officer, specifically an FBI officer, carries out a search that violates the Fourth Amendment, the officer can claim qualified immunity if they can demonstrate that a reasonable officer would have believed that the search was following the Fourth Amendment. The court should inquire whether a rational officer could have reasonably believed that the search without a warrant was illegal, taking into account well-established legal principles and the information known to officer. The Supreme Court also determined that subjective beliefs regarding the search are inconsequential. Furthermore, the Supreme Court in case of Harlow versus Fitzgerald, 1982, established that federal government officers have the right to qualified immunity. See, the court justified its decision based on the necessity to safeguard officials who are obligated to exercise discretion and corresponding public interest in promoting the energetic exercise of official power. The court upheld total immunity for some activities of government officials such as president and prosecutors. This doctrine protects individuals from criminal prosecution and lawsuits as long as their activities are within the parameter of their professional responsibilities. The court further established that, like all other federal officials, those seeking absolute immunity must demonstrate public policy necessitates such a broad exemption. The court has set a two-part standard that government personnel must meet to qualify for absolute immunity. Number one, initially, the official must demonstrate that the duties associated with their office include a level of sensitivity that necessitates complete immunity. Furthermore, the official must provide evidence that they were fulfilling the safeguarded duty associated with their role when carrying out the conduct in question. The Supreme Court analyzed the issue of immunity for police officers in the case of Melee versus Briggs, 1986, specifically about their actions based on erroneous warrant. The court examined that qualified immunity does not apply to a police officer who unlawfully detains an individual based on a warrant if the officer could not rationally believe that there was sufficient evidence to support the order. Responsibility is determined based on the course of action that an objectively reasonable officer would undertake. Students, moving on, in the case of Pearson versus Challan, 2009, the Supreme Court determined that although the Saussure test is beneficial, using it in claims involving qualified immunity is not mandatory. Instead, a trial judge should have a greater latitude in determining whether to apply Saussure test or not. The court determined that if the law does not prove that the search violates the rights, an officer searching is entitled to go ahead with the search. In the case of Safford Unified School District 1 versus Reading 2009, the Supreme Court ruled that if the Fourth Amendment right of a person to be protected from unreasonable search and seizure is violated, the individual searching may still be protected from legal action under qualified immunity as long as it is not evident that the search violated Fourth Amendment according to established legal precedent. Nevertheless, this ruling was made in a specific situation when a school official was searching for pupil to look for illegal materials. The Supreme Court has always shown tremendous respect towards searches conducted on kids within the school premises, making this ruling more limited in scope than earlier rulings on qualified immunity. The Supreme Court's ruling in Vega versus Teco 2022 established that violating Miranda rights does not serve as a legal foundation for a 1983 claim. Instead, the court stated that Miranda established a series of preventive regulations that specifically aimed to prohibit the use of statements collected that violated those regulations. Additionally, the court concluded that extending Miranda rights beyond their current scope would impose significant expenses on the legal system. Now let's start with the conclusion. Therefore, it could be safely understood that a case's admissibility in court is heavily influenced by the plaintiff's and defendant's ability to sue and be sued. The ability to sue or be sued depends on several factors, including fairness, effectiveness in maintaining law and order, municipalities and public corporations, friendly links to the state, foreign adversary, etc. Qualified immunity solely pertains to lawsuits targeting government officials in their capacity rather than lawsuits filed against the government seeking compensation for the actions of these officials. Qualified immunity is commonly invoked in the situations involving police officers, but it also extends to most other officials in the executive branch, although judges, prosecutors, lawmakers, and other government officials are not granted qualified immunity. Most are shielded by alternative immunity principles. Government alone will never be able to do it. Only the people themselves must utilize the law to bring justice to the doorstep of the large masses of the country's people. With this quote of Justice P.N. Bhagwati, we come to an end of today's lecture. Thank you so much for the patience listening. Have a good day.